Welcome to Empowered. I'm Elizabeth Naumovski. Love may bring families together, but without the right plan, it could also leave them divided when it matters the most. In today's world of second marriages, blended families, and evolving financial lives, estate planning is no longer just about assets. It's about clarity, protection, and preserving relationships. So, why are so many families still getting it wrong? Today, we're unpacking the costly mistakes, the difficult conversations, and the first crucial step every woman should take to protect the people and the future she cares about most. I'm joined by Rachel Goldman Robinson, a partner at Tork and Mains, LLP, and we're discussing modern estate planning for families. Rachel, welcome back to Empowered. I'm so happy that you're here again today.
Thanks, Liz. Thanks for having me.
Okay, so let's just dive in. With so many people entering second marriages later in life, what are the biggest estate planning mistakes that they're making?
I think the biggest mistake people make is assuming that everything's just going to work itself out and that my family will all get along after I leave. And, I don't really have to do anything to preserve those relationships. And with that in mind, I think a big mistake is not having something like a domestic agreement in place with the second spouse, something that sets out what actually is going to happen, that explains the rights, that preserves certain assets. Not having that document in place is something that really can end up causing a lot of fighting between the second spouse and the children from the first marriage. So it's having in place and actually taking the steps to put some document in place to avoid fighting.
So, how should blended families approach dividing assets between a new spouse and children from a prior relationship?
That is a really tough question, and it comes up a lot. There are questions about preserving assets. So, let's say somebody has family assets from, before the second spouse came in the picture, and do they want to gift those to the children? Do they want to gift those to the children right away on their death, or do they want to have those assets in something like a spousal trust that the assets are there and the spouse can enjoy the income, but ultimately they're preserved for the next generation? But when making those decisions, they also have to think about the tax implications because any assets that are distributed to the children of the first marriage while the second spouse is alive will attract capital gains tax if they're capital property. So there's a lot of things that have to be considered, but more often than not, something like a spousal trust is used to ensure that the spouse does have access to some form of income and support, but that the family assets are ultimately going to go to the original children from the first marriage. Another thing to consider is making the second spouse joint on certain property. So, if somebody really wants to ensure that their spouse is protected and has access right away to money, they might put the spouse on certain bank accounts or certain non registered investment accounts as a joint owner while putting other assets in a spousal trust.
So, there are a lot of people that are not getting married now and they have common law relationships. So, do common law spouses have the same inheritance rights as married spouses?
Yeah, that's a great question. They do not. And it's a common misconception that,
Mhm.
I've been with someone for a few years, and even though we're not legally married, I still have all the protections that would be afforded to a legally married spouse. A common law spouse does not have the right to make an equalization claim on the death of their spouse. They also don't have the right to inherit under the laws of intestacy. So if their partner dies without a will, they don't have the right to get a portion of the estate automatically the way a legally married spouse would. A common law spouse does have the right to make a claim as a dependent against this estate of the partner that passed away, but that ends up being a big legal litigation matter where they have to prove their needs and they have to prove that they were dependent, and it can cause a lot of issues. So, if somebody is in a common law relationship with no intention of getting married, or even if they are going to get married, again, something like a domestic agreement is really prudent to consider putting in place.
I'm really glad that we talked about this because, as you said, there is a misconception, and I think people need to understand what their rights are and what they can get and what they can't get because it's really, really important to have that knowledge.
For sure.
So, when we come back from the commercial break, what I want to do is talk about some of the issues that typically trigger estate litigation between siblings because things are not as easy as they seem. So please don't go away. We'll be right back with more. Welcome back to Empowered. I'm Elizabeth Naumovski. Today's topic is modern estate planning for families. So I had mentioned this, Rachel, before we went to break. What are some issues that typically trigger estate litigation between siblings?
So, estate litigation, surprisingly, isn't usually actually about money. Sometimes it is, but there's a lot of emotion involved. It's usually about fairness. A lot of the times it's about, how did mom or dad treat you during our lifetime while they were alive? And there's a lot of emotion that ends up getting unpacked through that process. A lot of the times it's about unequal treatment, either during the parent's lifetime or during the will process or what has been provided for in the will. It's also through a lack of transparency where parents are doing things either during their lifetime or in their will and they're not communicating it with the children. And at the end of the day, the second spouse, the second parent passes away, and all of a sudden there's this big eye-opening moment where children see how other children were treated or what someone's getting under the will that another person isn't. And that can lead to litigation. And another thing that really leads to litigation often is when one of the siblings is in a position of control. So whether it's during parents' lifetime and that sibling has been the attorney for property under a power of attorney for property and has had access to the accounts and has been dealing with the money, and the other sibling is now, seeing certain things that may have happened or there have been red flags. And so they start to contest things or it goes to litigation. But a lot of the times it's also about the dynamic between the siblings and their past growing up together and the emotions that come along with that.
Well, it's a lot to unpack. Um, want to talk about the cost of living because it's high right now. What should parents consider when loaning or gifting money to a child to help them out?
And so this I see a lot, and I deal with a lot in my day to day practice. Parents want to help the children. There may be multiple children. And the biggest question is, okay, are you going to do this as a gift? Are you going to do it as a loan? Either way, it needs to be documented. And when we talk about litigation, from your prior question, this is one of the things that does lead to litigation, where it's not clear what the intention was when a parent gifts or loans money to a child, and whether there's going to be an equalization. So one child might think it was a gift and another child may think it was a loan. And if there's not something like a letter of intention or a deed of gift or a promissory note to evidence what the actual legal structure is of that transfer of money, then that can certainly lead to litigation. So we talk about things with a loan like, well, what happens to it on death? Is it forgiven? If it's forgiven, we need to put that in the will. Otherwise, the child will actually be indebted to the estate. And that gets into equalization issues with the other child. And if it's a gift, well, is the other child to be equalized at the end of the day? If parent was gifting, the child one money during child one lifetime, should child two then get some form of equalization? So really, the intention should be documented, and that will help show the parent's intention, and it will help to avoid litigation down the road.
So, is there anything parents can do while they're still alive to reduce the risk of their children fighting after they're gone?
So, this is always an interesting question because I have clients who say to me, should I be transparent and should I tell my children my estate plan? And will that help them not, fight at the end of the day? And the answer is often yes, because if you have harmony within the family and you're doing whatever plan you're doing, then, letting everybody know will help. I've seen cases, though, that are really unfortunate where a parent decides that they're going to tell their children about the plan that they're going to do. And guess what? The children all start fighting while the parent's alive. So now the parents got to deal with all of these issues that may have arisen when they were dead, but they wouldn't be there to actually see this, awful interaction and carry this burden with them. So, communication is important if it's the right situation. And at the end of the day, the parents really do know the family dynamics. They know how children, and so it's important to figure that out before they do communicate. And another thing that they really should consider is choosing the right executor, because that is another way that they can decide today who will manage the estate down the road, with the view of trying to avoid, fighting and the children having negative interactions when they're gone.
It's also a good idea to have an executor that lives within the city that you live in the same country too, isn't it?
Oh, for sure. Certainly the same country, because if you have one executor and that executor lives in the US, for example, you're going to run into non residency issues for the estate. And that's a whole other topic. But you certainly need the right advice in terms of who to select. And if anyone is out of country, then that certainly warrants talking to a lawyer.
Welcome back to Empowered. I'm Elizabeth Naumovski. Today's topic is modern estate planning for families. Rachel, let's talk about children. Is adding a child to the ownership of an asset ever a bad idea?
It's often a bad idea.
Okay.
It is often a mistake. And we deal with situations. I mean, I saw a horrible situation early in my career of a grandmother who came to us, and she was in her 90s, and she had added her two grandchildren to title to her home because she had been given advice that this is what she should do to avoid probate taxes on the value of her home. And lo and behold, she had to sell her home to get the money to, have her fees to pay for the nursing home and the care that she needed. And her grandchildren asserted their ownership rights. Her intention of putting them on was not to give them ownership, but they, asserted their rights as an owner, and it ended up going into litigation. So there are other ways to avoid probate that don't involve putting a child or grandchild on title to the asset. There are tax issues that can be created. It can expose the asset to the child's creditors. It can cause conflict with the other siblings. All of that being said, if a parent does want to put a child on title to the asset for various reasons, and it does happen, the intention needs to be documented. There needs to be a trust document in place to show the relationship and that the child is actually on title as a trustee, to avoid the child asserting ownership rights at the end of the day, either during the parent's lifetime or when the parent passes away.
Okay, so let's go back to executors. How important is the choice of executor and or trustee? And can the wrong choice create conflict within the family?
Oh, for sure. This is one of the most important decisions, I think, that somebody makes when they are putting their plan together. It's a decision that is going to impact how the estate is going to be administered after death. Even if you put one or two or three people in, there should be mechanisms for decision making. So if you have two people acting together, you should have wording in there to talk about, well, what if there's a stalemate and they can't agree on a decision? And if you have three people acting together, there should be something like a decision of majority clause, or one person has to form part of the majority. The other really important thing is naming alternates so that you don't end up having to go to court. So if these people can't act, who's going to fill the spot? And I have clients who go further with third alternates and fourth alternates. And it's really a very prudent way of planning the estate to try to avoid any sort of litigation.
So, beyond distributing assets, I want to talk about wills. Like, what else can a will actually do for a family?
Yeah, so a will can do a ton. Like the will can distribute the assets and say, here, everything goes to my children, and they get it outright, and that's the end of it. But a will can also do things like have guardianship appointments. It can include trusts. It can protect vulnerable beneficiaries. So if you have a beneficiary that has spendthrift issues or creditor issues, or if you have a disabled beneficiary, you can have something called a Henson Trust. It can have staged inheritances. So instead of your children getting everything, let's say at age 21 or at age 18, if there's no trust in place, you can actually have a trust that has distributions of capital at various stages. You can have a lifetime trust. The will can set out who's in charge, how decisions are made. For business owners, it's really important. It can talk about succession and continuity of the business. It can do things like putting voting shares in a special voting trust. It really can create so much more than just a quick distribution of assets, and it can help to leave the legacy that somebody wants to leave when they die.
So, a lot of people say, oh, I don't want to go to a lawyer because wills are so expensive. What are your thoughts on online or digital wills?
So I've been asked this a number of times recently, and I think my answer surprises people because I'm not opposed to online wills. I think that they have a place, and I think that they are perfect for the right candidate. So I think the right candidate is someone who has straightforward assets. They don't have business ownerships. They have simple family dynamics. They don't have children or beneficiaries who require complicated trusts. I think that that's okay. I think having an online will that's properly done is better than not having anything in place at all. It's not ideal for someone like who has a blended family or who has, tax issues. There's also a place for the lawyer to be involved with an online will. So if someone wants to save fees from the lawyer, not drafting the documents, they still might want to meet with a lawyer or engage a lawyer if they want to do things like tax planning or probate planning, or have any sort of cross border planning. So, anyone with a US beneficiary or a US spouse shouldn't use an online will. But for certain people, online wills are actually okay.
Okay, so don't go away. We'll be right back with more. And we're going to talk about what role trusts play in preventing family conflict. Welcome back to Empowered. I'm Elizabeth Naumovski. Today's topic is modern estate planning for families. And I am joined by Rachel Goldman Robinson at Torkin Maines LLP. Rachel, okay, you talked about trusts. If you could just tell people a little bit of a trust and what role trusts play in preventing family conflict, please.
Sure. So trusts are a huge part of my practice. There are inter vivos trusts, which are trusts that are created during someone's lifetime, and there are testamentary trusts. So those are trusts that are created under a will when somebody dies. Those trusts don't come into effect until somebody actually passes away. Those trusts really do help to prevent family conflict because I mentioned earlier in the segment about spousal trust. So, a spousal trust is a trust that will be set up for a surviving spouse. It allows for the tax rollover when the first spouse passes away, but it prevents that surviving spouse from having unfettered access to the assets, which at the end of the day preserves the assets and the capital for the next generation or the ultimate residual beneficiary. So it really does prevent family conflict because there will be mechanisms in place for distributions to the spouse. The spouse will be provided for, but the children of either the first marriage or all of the children, if there are multiple children from different marriages, may be, provided for at the end of the day when that spouse passes away. And we also do trust, like I mentioned before, for all sorts of beneficiaries. It helps also to prevent fighting if there's a beneficiary that, can't necessarily control the assets because of addiction issues or bankruptcy issues or whatnot. So the trust is a mechanism where the beneficiary can have access and can enjoy certain fruits of the asset but not actually hold the asset itself.
So, I want to talk about probate because there's a lot of talk about probate and a lot of confusion about probate and when it may or may not be needed. So, can you please educate us?
I can, Liz. We could do an entire segment on probate.
Well, maybe you'll
I
have to
could
come
talk.
back and we'll have a discussion on that.
I will. I'll come back and we could do a probate topic because probate is very misunderstood. Probate is not needed every time somebody passes away. Probate, which is the slang form of having a certificate of appointment issued by the court, it's really something that we get that's determined by the asset itself. So if an asset requires probate, so if an institution requires probate to transfer the asset when somebody dies, then that asset, the value of it will have to be in a probate application and subject to a approximate 1.5% probate fee. There are ways to avoid probate. The easiest are on assets like life insurance or registered plans where you can make a beneficiary designation so that the asset, the proceeds flow directly to the named beneficiary. That avoids probate. Shares of private corporations can avoid probate by the use of dual wills, along with other assets that might not need probate. Jointly owned assets with rights of survivorship, like a joint account with a true right of survivorship, or land that's registered in someone's name with another person as a joint tenant, those will pass without the need for probate. So, really, probate is dictated by the asset and the third party institution that will require it or not.
Okay, so we have a minute left, and I think this is important. What are some common planning mistakes people make when they don't have a proper professional to give them advice?
Okay, so certainly a common mistake is people either don't know their assets or they don't understand how they're actually owned and what the ownership means for transfer on death. Things like jointly owned property and what will happen to that property, or not understanding the tax liabilities that flow through when assets are transferred to other people. I think failing to name backups and proper estate trustees is a big problem. Underestimating family dynamics is also a common mistake that people have, where they don't really appreciate the nuances and what's happening within their family. So having a professional in there is really important. And another mistake I see all the time are wills that are drafted with poor language, unclear wording, unclear drafting that ends up leading to litigation.
Rachel, thank you so much. This has been such a pleasure and so educational. I know a lot of people will benefit from this episode.
Thank you. It's so great to be here.
Rachel wants you to know estate planning isn't just about money or assets, it's about people and relationships. The best plans don't just transfer wealth, they protect relationships, prevent conflict, and strive for family harmony. At the end of the day, a good estate plan is a gift to our family. I'm Elizabeth Naumovski, and I'm here to empower you and make frugality fashionable. Thank you for watching. Bye for now.